closing arguments. I want to bring in our special guest that I have with me, Marcia Minot, who is a former prosecutor and a criminal defense attorney. Thank you for joining us. I have to ask, so to me, this was the main point of the defense closing argument. Erika Stefanko is a scapegoat of Chad Cobb. If you heard that, go back to your prosecution mindset. Well, how would you rebut that statement?
Well, I'd have to rebut it with her phone call. That phone call is the best evidence that the state has. And I would ask the jurors to pay attention, not to defense counsel's statements, but to the statements of the actual defendant, where she's actually admitting to her role and her complicity as it pertains to this murder.
And do you feel like the defense attorney, I think he's done a very effective job in the closing argument, really confusing the jury, putting out lots of different information about why Mr. Cobb might have done this and the motive and the revenge. And so I think the jurors listened to all that and are going to have to go back and remember, wait a minute, closing is not evidence, but rather we have to talk about the evidence presented in the testimony. Do you think that's going to be difficult to do?
Well, I was hoping that defense counsel would have honed in more on what the evidence was in this case and not just the facts, and the fact that the evidence does not point, or there is no forensic evidence that connects the defendant to the crime of murder. And I didn't feel that. I didn't feel that passion that I was hoping would come across, where, you know, she's innocent. She's not participating. He's seeking revenge. The children have been the motive regarding why he hurts people. He hurt their mother because of the children, and now he's hurting, you know, Erika because of the children. So I would want for the defense to have honed in more on what the state failed to prove and what the evidence is in this case, which is that his client is innocent.
All right, Marcia, you're going to stay with us. Thank you so much. We do need to take a quick break, but we'll be right back on the other side. You won't miss a thing. Bring back in our special guest, Marcia Minot, still with us, a criminal defense attorney, but a former prosecutor. I felt that prosecutor was very passionate and really boiled it down to a very simple instruction to the jury, which is, listen, if you believe her in her own words, then she's guilty. What are your thoughts?
That is powerful. When you have a defendant's statement, that's the scariest thing for the defense and the most powerful thing for the prosecution. And the fact that he came in with more passion and started explaining that just believe her words, and it's evidence. Her words are evidence. Believe her words. She is actually guilty. That is powerful.
And I liked how he got into his closing argument, not just believe her words, but listen, she didn't know she was being recorded, so she didn't know to lie or make anything up. And it was a 3-hour conversation that was a conversation. She wasn't being examined by Cindy, Mr. Cobb's mother. She wasn't being asked specific questions, but rather she was just talking about it. And he also really focused on use your common sense. And how hard do you think it is for a jury to sift through an entire week, right, of evidence, of testimony, to really come down to the end of the day and say, it is common sense? Did the state prove this beyond a reasonable doubt?
It is tough, and that's why it was critical for the defense to break down the rule of law for the jurors and break down the facts and to be able to explain to them why he believes his client is innocent and why he believes the state has failed to prove her guilt beyond a reasonable doubt. Jurors sometimes get confused because we forget that they're regular, everyday people. This is not an arena that they practice in, or they're not familiar sometimes with how the process works. Sometimes it's their first experience with the court system. So it is critical for you to break down the rule of law, what they have to do, so that they don't get confused when they go in the jury room regarding deliberation.
That's right. And it's my understanding they haven't been able to take notes. And Mira, with that, the jury instructions, and I am a sitting judge, it doesn't matter to me how well written they are, how much agreement there is between the prosecution and the defense and the jury instructions and saying these are the best that we can do and this is fantastic, let's give these to the jury. They're cumbersome because they're reciting the law, and often that's not necessarily well written. It doesn't always sound like it's plain English. So with the jury instructions and no notes, in your opinion at all, does that affect the ease with which the jury is going to be able to sift through the evidence?
I think it's going to be difficult. And the reason is because I've had cases where the jurors have actually had to refer to their notes in order to get other jurors to either come on their side or vote a different way or to see evidence a little bit differently. No notes is kind of scary because most of us know that our memories fade, and those memories can also be distorted by facts. So, of course, I would be concerned about them not having any notes. One thing that's peculiar here is that the jury charges were read before the closing arguments. That is uncommon in most jurisdictions because you want to have the facts before the jurors get the law. And in this situation, they got the law before they got the facts.
Yeah, excellent point. I don't disagree with you. It is a little bit unusual. We are going to have continuing gavel-to-gavel coverage of Ohio versus Erica Stefanko. Stay with us here on Court TV Live.